Hey guys, this is attorney Philip Adams with the law offices of Philip Adams in Shreveport, Louisiana. I wanted to take some time today to talk to you guys about why I believe an investigation is the most important aspect of successful representation in a criminal defense case. I've often been asked by clients what I think is the most important aspect of a criminal case, and most people typically think that a trial is the most important aspect of a case, and that's often because trials get a lot of publicity. But the reality is, based on my opinion and years of experience, the investigatory stage of the case at the pretrial level is the most important stage of any criminal case. And why is that? Well, if you think about a trial is often just a culmination of months of hard work, preparation, having multiple court hearings, client meetings, witness interviews, sifting through evidence, and so forth. So a trial is almost like a play that you perform in high school or junior high, and a jury and members of the public who attend the trial will see the play, but they will not see the weeks or months, sometimes even years in some complex criminal cases that go into preparing for what may ultimately result in a trial. They won't see the dozens and dozens and dozens and dozens of hours of going to a crime scene, thinking about what questions you intend to ask witnesses, looking at evidence, and so on, meeting with clients, interviewing witnesses. They will see the polished end result. My opinion about why I think the investigatory stage is the most important aspect of any case is based on years of experience and my personal philosophy and how I represent my clients. I've had cases in which I've been able to mount successful defenses and achieve good outcomes against often overwhelming odds. And that's only been possible through having mounted thorough investigations on behalf of my clients. But not just any investigation can suffice in a criminal case. You can't leave any stone unturned, because sometimes stones that are unturned could have underneath them key evidence in your cases. So in working each case I take on, I spend a majority of my time at the investigatory stage, and I do that to where when I arrive in court for the first time, I'm confident that I'm well prepared on behalf of my client, and I can meet my ethical and professional obligations. It takes time to proactively build a foundation for a home, if you're constructing a home, for example. In the same way, it takes time to build a successful foundation for a trial if you know that the case is going to go to trial. You can't just take the words of police officers at face value or the words of witnesses, because police officers and witnesses are human beings, and human beings are fallible. Sometimes human beings lie with ill intent. Sometimes human beings are simply mistaken and don't have any ill motive. And it's the job of a competent defense attorney to come into a case and thoroughly investigate the case to look for internal consistency and external consistency. Internal consistency arises whenever witnesses, for example, make allegations or claims that don't have major discrepancies within them. External consistency arises when witnesses make allegations that are consistent with what other witnesses say and with any physical evidence recovered from a crime scene. So you have to make it a point to thoroughly investigate each witness who is involved, learn about the personal and criminal backgrounds of all witnesses, including any police officers on the case. You often will issue subpoena duces tecums for documents, witness subpoenas for testimony, request copies of any documentary evidence, audio recordings, video recordings, including body camera evidence, dash camera evidence from police units, surveillance footage from businesses, for example, if you're dealing with, say, a theft or an armed robbery case or home invasion. Copies of police reports, obviously, you want to get copies of all that. You may even have to hire investigators to search for additional evidence if you have a lead that suggests that potentially useful evidence might be uncovered through additional investigation. And you will have to visit the crime scene, especially for major cases, before going to trial so that you have an on-the-ground perspective as to what may have happened during the crime. You can never know ultimately what happened if you weren't there as a witness. However, by going to a crime scene, at least for me, I often have strokes of brilliance from just seeing how things physically are laid out at a crime scene in terms of having more context in the case. You can get a lot of information from reports, but as the expression goes, a picture is worth 1,000 words. Well, I would say that on scene, on the ground perspective is worth 1,000,000 words. It's important to spend a lot of time in the investigatory stage and take your time. This is not a stage that needs to be rushed, because if you rush to this stage, you will miss something important. I've had many cases dismissed outright at the felony stage, an investigatory stage, excuse me, because of work that was done at that stage. And I was able to spare clients in those cases the stress of trial because of work that was done proactively. Uncovering favorable evidence derived from a meticulous investigation can lead to desirable resolutions. Not always, but often having more favorable evidence can lead to desirable resolution and spare your client this unnecessary stress and effort that's associated with a trial. Sometimes you may have favorable evidence uncovered in a defense investigation, and a prosecutor may still refuse to dismiss the case because the prosecutor may still believe that he or she has a strong case, and that's okay. When situations like that arise, you have to put your evidence before a jury and let that jury make an ultimate determination on what it thinks about the evidence that you have. Nobody's liberty should be handled lightly. Unfortunately, I've had some clients come to me for representation who were told that, not told, but who were not thoroughly questioned by prior attorneys that they had, or at least that's what I've been told by some clients. And in my opinion, defending somebody who's accused of a crime is a privilege. It's not a right. No defense attorney has the right to have a client. It's important to always recognize that on behalf of your clients, treat them with respect and with diligence and competence. And if you do that, they will feel confident that they're being represented by somebody who's really trying to give meaning to the Bill of Rights that we have within our federal Constitution and our state Constitution. Thank you.